Adjournment request, if any, from item number 1 to 6. From what item number 7 to 10.
May I please, Your Lordship? I beg to mention for item number 10. Lordship, due to death of the father of S. Thakur, may I pray for quick adjournment of this case, my lord? Object.
From item number 11 to 20.
May I please, Your Lordship? I beg to mention item number 11. Lordship, the government instructing council, Mr.
What the name of the instructing council?
Lordship, it's a bit complicated name.
Complicated.
No, his name is a bit complicated.
Speak out.
Due to some medical emergency,
No, but what's his name?
Lordship, I think.
Anyway, instructing council.
Your Lordship, due to some medical emergency, he could not come to Guwahati, Your Lordship. So I beg to, the matter may be adjourned.
To the consent of the parties, we have fixed this matter.
My lord, actually, in this matter, initially there was no stay order, my lord.
Yeah, we
Subsequently,
understand on contempt.
there's some urgency because lots many posts are being advertised. We are not in a position to apply. Anyway, my lord,
That's
today,
why only after hearing for some time, we get the matter adjourned.
next week.
No, sir.
Hey, only.
Lordship,
Nothing.
because I'm making this prayer because my lord, the instructing council who is from the Sikkim government council, he has some difficulty. His father liver transplant has been.
So now
Hello.
what do you want?
Lordship, let it come up on 29th of August, Lordship. We'll be here. We will not take any further
So, my
action.
lord, my learned friend
Well-
senior will argue the matter. I know it's required, but then he has already been there for the last almost more than a year.
But
I don't think instructing council's role is so much. I can appreciate today he has
it has to be
difficulty.
there, Lordship.
Let it be sometimes before 15th of August. maybe.
Lordship, he won't be available, Lordship,
So what?
today. That's just one simple prayer, Lordship.
No, my lord, I am objecting to that prayer.
Chief.
Lordship will have it, today they have difficulty, that I appreciate.
He
But
has
it
gone
can't be
today.
for another one month. Because people are coming from seeking every time, my lord.
No, we had informed.
No, you informed us only for today till 29th, not regarding 1 month.
That 29th of August, Lordship, I have informed.
अरे इंस्ट्रक्टिंग काउंसिल के लगे हैं सीधा कहे कि इसको रिवॉर्ड
The problem is that in the third week and fourth week, start from 12. Maybe this bench may not be available. For that. Okay. The council for the plat had submitted that as the instructing council is engaged in some medical emergency, the matter may be fixed for 29th of August. Stop. When it council, when council for the respondent has vehemently opposed this request and has submitted that since the stay order is operating in this matter, the matter may be heard at the earliest. Taking into consideration the above facts and circumstances of the case and looking to the fact that the instructing council is involved in medical emergency, we list this matter on 29th of August 2024 with this understanding that no further adjournment would be.
Highly request. Highly request. May please, your Lordship. Lordship, with regard to item number 15, your Lordship, yesterday we have filed an affidavit, Lordship, that may be called for your Lordship. Very small affidavit is there, Lordship. Very small affidavit, Lordship. Hardly 4 pages affidavit.
That is regarding this appointment of RAS persons.
APSC cases, your lordship.
APSC cases?
Yes, lordship, those candidates, lordship, who leftover candidates.
What affidavit they have filed now?
Lordship, again, the government have, the person department has filed an affidavit against them, we have filed a reply, lordship, just a very small affidavit.
They have already clarified their stand that they are not,
Exactly, lordship, with regard to that only, we have filed a very one-line affidavit, lordship. It's small, very
they,
small.
they have already made their stand clear on the last day
Yeah.
that we are not going to,
Yes, lordship.
approve this, whatever the,
Only with that
Taking
regard only,
condition
we have filed then a very small affidavit, your lordship. That may be called for your lordship. Yes.
eighth of August. This item number 14 to
Lordship, that will be item number 15 to lordship, that series, lordship, 15, 16,
14 to 18.
14 is
14
also
to 18.
14 to 18.
connected.
14 to 18. Only in 15 lordship, we have filed the affidavit.
14 to 18. Yes.
Any other request for adjournment?
Item number 37, Lordship. There was some communication again between with my council, Lordship. ACC. So could it be taken up tomorrow, Lordship? Item 37.
Tomorrow,
Very short issue is involved there.
Tuesday.
Lordship. Deeply obliged, Lordship.
Lordship, item number 20, the status filed on affidavit in opposition yesterday. Can it be brought to report?
Item number,
One affidavit, my lord.
item number
Item number 20.
20 is again 19 and 20. These are the parted
Now,
matter.
we have, my lord, prepared with the.
19, 20,
Yes, yes.
21.
We are prepared, my lord. Only I
23.
pray that, my lord, lordship will be, call for the.
What's this controversy is about?
It's regarding, my lord, termination of illegal appointees, madam.
Those,
Yes, Dibrugarh and Gwalpara. my lord.
mistakes, yes.
I have served copy to all, my lord. yesterday. We are prepared, my lord.
No, this is at the request of land council, but the appellant,
No, I'm not praying for adjournment, my lord.
you are praying for adjournment or what?
No, I prayed that, my lord, that affidavit may be called for the.
That's that.
Always, sir.
Any other request? Daily list for orders item 1.
Lordship, they filed an affidavit, your lordship, yesterday, lordship. And in total, lordship, 15 numbers of affidavits have been filed by the respondents. We want to reply to all of them by filing one consolidated reply, lordship. Yes, your lordship.
You are seeking time for that.
Yes, your lordship.
The reply 21. AL is there.
15. One file.
In concept of the submitted that is going to file a consolidated affidavit in response to the affidavits filed on behalf of the respective respondents. He placed some time. Please notice that the state, the respondents have filed their response in counter to the writ petition. And therefore, we are of the opinion that matter requires a complete, final hearing. Hence, admit learned counsel for the petitioner may file the required affidavit. List in due course.
Lordship, I'm being led by Outsourcing Council. Can I pray for a specific date, your lordship?
Specific date, due course, you take the specific date from the registry.
Public. Deeply obliged.
No need to issue notice, the parties are already.
Item 2 and 3.
Yes,
I have received instruction from the government, my lord. Terminated period has been regularized by the government, my lord.
the
Terminated period of the petitioner has been regularized by the government.
regularized.
Yes, my lord.
Now what remains?
Now, my lord, director will submit the proposal for area salary to the government. And after sanctioning from the government, my lord, it will be released
Yeah, let me concept of the.
in item number 2. And
when
item number,
the respondent has submitted that the secretary to the government of Assam has already issued an order regularizing the services of the petitioner from 21st of May 2012 to 18/1/2014. Submitted petitioner, the more than one. Yes. Petitioners from 21st of May 2014 to 18/1/2000. 21st May 2012 to 18/1/2015. It is submitted that now the director. Which director is there? Director
secondary education, my lord.
secondary education would pass necessary orders pursuant to the order passed by this court within a period of.
But it will, at least 1 month will require to process the salary and now gradually to release the salary, my lord.
Just after 4 weeks.
In respect of item number 3, my lord, it is under consideration regarding regulation of the termination period, my lord.
So
It will take 15 days time, my lord.
for the secretary,
Yes, my lord.
then it, Council Mr. Bhatnia has submitted that the 3 day, the 3 weeks time be granted. In item number 3, what she take it? 3 weeks be time be granted to do the needful on the part of the secretary. Which department?
Secondary
Department of
education.
School education.
Obligation.
Just after 4 weeks.
Item 4.
This is appeal against the.
The notice has not been served.
On 22nd, there is a note of office note, but neither etiquette nor unsubmitted notice is written.
Yeah, so what to do now?
Lordship, on last year, Lordship passed order that we should wait for another week for service of notice.
Let the notices be served.
Lordship, here some urgency is there.
No urgency without, once we have issued notices. And there is an order that subject to the.
Yes, Lordship.
Notice of, service of notice of the period of interim will be considered on the returnable date. So if it is not served, then what to do? Get the fresh notices or
Because notice and unsub notice has not been returned, neither etiquette.
wait return of, notice of sole return for 2 more weeks.
Item 5.
Yes.
My lord, in this case, my lord, one writ appeal was disposed of by this honorable court at page number 50, annexes C2. And while disposing this writ appeal, my lord, I take a lordship to page number 69.
60,
Page 69, my lord.
59,
Page 69, my lord, 69.
69.
Yes, my lord.
Yeah.
Para 49, my lord.
Yeah.
The present case falls within the provision of section 47(1)(d) because on account of the expiry term of the ADC approval, a situation has arisen in which the administration of the ADC approval cannot be carried out in accordance with the provisions of this act. And such the state government in exercise of the power under section 47(2)(b) can appoint an official or authority as administrator to function and exercise the power and duties conferred and imposed upon the ADC approval under the Act of 1971 and any other law. 50. While making the above observations, we are conscious of the fact that the learned single judge of the Manipur High Court by judgment dated 2/3/2021 passed in WBC number 613 of 2020 and other connected petitions has caused the order dated 30/11/2020 issued by the government appointing the Deputy Commissioner as administrator of the Autonomous District Council to exercise all the power conferred and imposed upon the council, treating it as illegal. However, we have reservation about the said view of the learned single judge, but we refrain ourselves from commenting on it since it is informed that an intra-court appeal against the judgment dated so-and-so is pending consideration before the division bench of the High Court of Manipur at Import. So, my lord, but because of this para 49, my lord, the pending writ appeals before the Manipur High Court, it may pose prejudice, my lord, because of this.
We have already said that they may take a different view. We
so,
we are
just-
not supposed to ask them. We have simply
that's why, my lord-
expressed their views.
No, I'm not, I was thinking about this observation made by, may not
This
influ-
observation, we made this observation as per our understanding.
yes, but it may not influence the,
Sir, that is for that court.
No,
Okay, we
no.
have simply said, we have reservation about the said view, but we refrain ourselves from commenting on it since it is informed that inter-court appeal is already pending.
yes.
Now it is open for the this Manipur High Court to take a different view.
Yes, my lord, but para 49,
Yeah, para
in
49.
view of the
we have
para
simply-
49,
We have, after considering this, as per our understanding, we have made certain view,
Yes.
this observations.
yes, my lord, my submission is the lawsuit may pass an order that this para 49 may confine only to this appeal, not to my, only some clarification. Only that
This
was not what it is, my lord.
clarification, we are not supposed to.
No, I'm
That
not
is
saying
for
that,
That is for the Manipur High Court to take a call.
yes,
Whether they agree with it or not agree with it, it is always open for that.
no, no, my lord, we approached the honorable apex court and honorable apex court, director us to approach this honorable court for clarification.
We have gone through that order. What is that order? You sought liberty to file a review. They said, yeah, clarification.
Yes, certain clarification. That's why
Certain
we are,
clarification, we are of the view there is no requirement of any clarification. in that.
no, only my prayer is that, my lord, this, it may not cause prejudice to the other parties in the present did appeal. But in my real, so you also may pass an order that this will confine to this particular did appeal, not my.
What do you mean by? So these are the observations after going through the provisions of the act. Maybe we are wrong.
Right,
Maybe we are wrong. We are not saying that we are always
Yes.
correct.
you're
Maybe we
absolutely
are
right. But my lord, the division bench judgment, my lord, persuasive in the High Court because of that, my lord.
That is for the Manipur High Court to take a call on that.
This is the only problem, my lord.
There is always contradictory views by different high courts.
Yes, my lord, they have the, but
One may follow, one may not follow. That
Yes.
is their discretion. Can be-
But my lord, my only problem is, my lord, while arguing that case, our decision bench may say that the Manipur High Court decision bench said no.
Well, this
matter has already been
situation is
decided by the decision
altogether
bench of the.
hypotheticated. Still, you have not argued the matter and pursue the court to take a different view. What's wrong in that? It always happens.
But my lord, it will be difficult that the division bench, this judgment of the division bench judgment.
So they may agree with us or they may not agree
Yes.
with us. It always happens. There are divergent views from the various high courts and one high
Yes,
court
my
may
lord.
follow,
Yes.
one high court may not follow.
Yes, but normally, my lord, the decision
What
bench
is
judgment.
normal and abnormal that we don't know.
This is the only problem, my lord. I'm not asking for review of the judgment passed by your lordship.
So,
Only,
your prerogative, you can even ask that. We have to decide it if it is maintainable or not, or any order is required to be reviewed or not. But so far as regarding these observations are concerned, that is as per our understanding, sir.
yes,
Maybe we may be wrong. We are not saying that we are always correct.
yes, your lordship is right, but ultimately, my lord, para 49 may automatically influence the.
Okay. This IA number so and so is preferred on behalf of the applicant with a prayer to to pass an order to clarify that the para number 49 of the judgment dated 15/3/2024 passed in writ appeal number 353/2023, writ appeal number 353/2023 will not influence in any manner deciding the batches of writ appeals being writ appeal number 18/21, 19/21, and 22/21 pending before the Honorable High Court of the Manipur. Having heard the learned counsel for the applicant and after going through the judgment dated 15/3/2024, we are of the view that no clarification is required to be issued in respect of the para number 40 and 49 and 50 of the judgment dated 15/3/2024 as the same, as the observations made by this court in those paras are as per were made after taking into consideration the provisions of law relevant by provisions of the relevant law. Hence, no force in this. The same is therefore dismissed.
Item 6 and 7.
Assam survey, the ward madam of survey. What is it?
This application,
Sorry, madam.
who moved this IA?
Yes, Lordship, it is me, Lordship. The filing of instant interlocutory application has been necessitated, Lordship, for urgent intervention of this honorable court. As Lordship, the respondent authority, more particularly the Forest Department, has initiated with the construction of a watchtower within the village of Bataguli, where all applicants are residents, Lordship. Now, these applicants, Lordship, few of them has only before this honorable court, rest are not there, and they pleaded in their instant PIL Lordship when eviction drive was carried long back 2013. Since then, they are the necessary party and they are party to this proceeding, Lordship.
Right.
Now, under that circumstance, Lordship, what has happened, Lordship, when they have initiated with the construction process, so this application has been filed, that until the decision now here disputed question, Lordship, regarding boundary, Lordship. that boundary of the village lordship that Kamsang forest sanctuary, that has not been decided yet. They have not demarcated
already
the
been-
boundaries,
That has
lordship,
already been decided, madam.
lordship.
That has already been decided.
But lordship, I have I have annexed here 2-3 notification, lordship, notification of, if your lordship turn page, lordship, kindly see page,
Notification of the boundary of the armed
government of
wildlife,
2000.
sanctuary is pending before the state cabinet.
2000, page 63, lordship, this Botaguli village comes at serial number 10, where this village was identified long back, lordship. This village was long back by the notifications, lordship, 2004, 6, and 16 and 17, lordship.
If you are aggrieved by the demarcation of the boundary of the
Lordship.
Samchang Wildlife Sanctuary, you take proper recourse. Here, we have not passed any order for, only simply said, "Okay, you demarcate the boundary of this wildlife sanctuary. And if there is any encroachment there, you have to remove it." That is what we have, that this petition is on.
My contention until decision of this instant PIL lordship, the construction process be
Construction of what? A
of
watchtower.
what station, lordship? That
Maybe. These can't be, this PIL is.
where
argue it on
this
merit.
applicants all
You
are
argue it on
apprehended,
merit.
that will be evicted, lordship, until.
You argue it on merit. We'll consider it. We can't pass any such order. You argue it on merit.
Yes, lordship.
When
Any date after 4 weeks, lordship?
the IN number so and so prepared on behalf of the applicants will be considered at the time of final hearing of the PIL petition number 27/2013. This PIL for hearing. Is it admitted?
It was very long time. It was
Admitted, lordship.
Looking.
from time to time, it was so much a matter, lordship. It was,
Okay, looking to the issue involved in this PIL petition regarding encroachment, regarding removal of the encroachment from the forest land, we deem it appropriate to hear this matter finally at admission stage. This for final hearing in the third week of August.
in the IA lordship, I have already received instructions. I would like to file a short affidavit, whatever,
In the meantime, the state may file counter to the IA.
lordship.
Until
I'll-
the-
Only one issue, the forest department, my lord, by order dated 27/5/24, there was some rationalization of the boundary of the wildlife sanctuary, wherein, my lord, the cabinet decision was to be taken.
Yeah.
And as per that order, my lord, because of the moral code of conduct that was,
That we have observed as now.
so, my lord, there is no specific, my lord, submission with regard to whether that decision has been taken or not.
Yes, lordship.
Clarify.
It has come to the chief minister. Chief minister directed that we have to take the final opinion of the State Board of Wildlife and National Board of Wildlife. State Board of Wildlife has taken it on board on 18th of July. This, and we are awaiting the instructions, the minutes of that meeting. And we are also pursuing the National Board of Wildlife. So once these two opinion comes, then the cabinet will take the final call.
You
Fine.
clarify
Because
this
we have
matter.
received two survey reports, one from the state survey and other from the Survey of India.
Then you get this matter resolved by the,
Lordship.
yes.
For admission, item 8.
My lord, that regarding that forest division without any working plan, probably they are, my lord.
My lord, we have instructions, my lord. Working plans are under, out of 21, my lord, 10 are prepared, my lord. Under draft process, my lord. It requires some more time, my lord. And the timeline is indicated in this process.
But then you have already implemented, this was in the April 2000.
Long back.
24. And
lord,
you sought
the-
time for remaining forest divisions.
My lords, these are under scrutiny, my lords. And my lords, there are two areas in Assam, my lords. One is the regular areas and other council areas. Regular areas, my lords, 6 months we can do it, finish it up. But the council areas, my lord, we need 18 months, my lords.
It will go to timeline of 18 months. Malad will kindly peruse the instructions. Malad.
18 months.
18 months. Malad. It goes to the ministry, Malad, comes back.
Yes, Government of India.
Government of India has to convey Malad his approval. Ten are approved, Malad. 4 are at a final stage. 7 are at a level of scrutiny, Malad.
Why 18 months is required for council areas? Why can't it be done in this, at the same time?
There are some intricacies involved, Malad. Council area, Malad, our jurisdiction is limited.
Affect the jurisdiction. What are the intricacies? If it can be done in non-council area
Malad.
at a particular time,
Malad.
why
This-
can't it be done in council?
I have not been advised properly, Malad. As regards that point, Malad, I'll clarify with the affidavit, Malad, why it is required, Malad, 18 months.
Which council is involved here?
Malad,
Which council is involved?
it is these
Dima
instructions
Hasao
are
and
revealed, Malad.
Dima,
We have. Three
listen, Mr. Dima Hasao and Karbi Anglong.
It says, Malad, areas.
You're talking about autonomous council.
Malad, 3 councils we have, both 3 councils, all 3 councils.
So we let this come.
BTC, Malad, KAC and Karbi Anglong Autonomous Council.
Those, concepts are party here.
No, Malad, they are not part.
काम हो रहा है.
देखिए Mr. D Gogoi. D Gogoi. Council for the Forest Department has submitted that, as stated earlier, amongst the 32 forest divisions, working plan in respect of 10 forest divisions has already been approved and implemented. However, in relation to the preparation and approval of the forest plans for the working plans for the remaining forest divisions, at least 6 months time is required. And in relation to the preparation of forest divisions for the preparation of working plans for the forest divisions falling in the council areas, at least 18 months time is required to stop. However, Mr. Gogoi has failed to explain that why 18 months time is required. Therefore, we deem it appropriate to ask the councils appearing for the, which 3 councils are there?
Minus these at page 3rd page of my affidavit, that instruction, Malad, this Karbi Anglong,
Bodoland Territory Council,
Council.
Karbi Anglong Autonomous Council
and Dima Hasao, Malad. That concluding paragraph
council for the standing council for the Bodoland Territorial Council and RBL, Karbi Anglong Autonomous Council and Dima Hasao Autonomous Council.
Yes, Malad. All 3
Council are
Karbi Anglong,
directed
Dima
to
Hasao.
accept notice
BTC.
and submit their response. Full stop. The names of the advocates appearing for the attending counsel appearing for the counsels be reflected in the cause list. Mr. Mehta may supply necessary. Mr. Mahanta may supply the copy of the record to counsels within a period of 1 week. Is this matter after 4 weeks?
Item 9.
Yeah, what about any proceedings in relation to this is pending before the NGT?
No, my lord, no proceeding pending, my lord. There was a, my lord, proceeding before the NGT, my lord, that has ended. With
That has
regard to all the rivers in the country, my lord. That has ended, and so far as this petition is concerned, this is with regard, only with regard to the Bhorolu River, my lord. And this was registered pursuant to a letter written by one C. Pratap Chandra Das. That you also will find page 4 of the PIL.
So what about the interim measures?
Interim measures also, we have filed an affidavit, which was filed on 9th of May, where we have indicated what are the interim measures we have taken.
10th of May.
19th.
Housing affairs, housing and urban
I'll-
affairs.
Yes, Lord.
Lazar Ali.
Yes, Lordship. So to reduce the waste, Lordship, door-to-day collection, number 1. Then we are trying to detect the sources of pollution, cleanup drives. Now coming to one specific steps we have taken at page 36, Roman 7.
Yes.
Desilting of River Bhorolu. GMC initiated desilting operations along the entire stretch of the Bhorolu River. This process involves removing silt deposits and other debris that accumulated at the bottom of the river, which can contribute to poor water quality and reduce water flow. Regular desilting helps in maintaining the river's depth and improves water quality. This river desiltation is being done every year at the beginning of monsoon. This year also we have done it. Number 1. Yesterday's case, Lordship, we have said that STP. These rivers are finally it is going to be connected with the rivers because the water is to be treated in those STPs. Then the sewerage process also, next Lordship will see that Borsola bill, yesterday what we have submitted before this honorable court. In the first affidavit, we said that in Borsola it was 23%, that was in February this year. Here it was in April, it was 60%. Yesterday I submitted 70%. So it is going to be commissioning from October. Identically, we have 2 other projects, one at Sorusala and there is another one which is a little bit away from the river. So these things are going on. These are stopgap arrangement. And finally, Lordship, once these 3 FTPs come into force, that in our second affidavit, earlier affidavit of 7th March 2024, we specifically mentioned about these 3 projects. That
Yes. That we.
sewerage system at 3 projects, one at Borsola, one at Poru Tilsako.
Okay, then furnish the project report after 8 weeks, 10 weeks. Progress report.
Progress report, yes, status report.
Having heard the learned concept for the party and after taking into consideration the affidavit filed on behalf of the
If it is in the last week of September, Lordship.
Respondent number 6, regarding the interim measures taken for containing the pollution in Haralu River. We grant 10 weeks further time to the respondents to submit the progress report regarding the project which has been undertaken for steps being taken for implementation of the scheme related to make the Baralu River pollution free. Just after 10 weeks.
Briefly obliged.
Item number 12 and 13.
In this matter, my lord, I almost completed my part on the last
Mr.
occasion.
Chaudhary, short time.
Mr. Chaudhary is supposed to answer. I'll just refresh your lordships if required. If required, my lord, if I refresh
Yeah.
till Mr. Chaudhary comes, my lord.
You
The issue-
refer to 2-3 judgments of the
Yes, my lord.
Kerala
The
High Court and
Supreme Court.
Supreme Court judgment, yes.
Yes, and one Delhi High Court judgment.
Yeah.
Kerala High Court judgment, division judgment was interfered by the Honorable Supreme Court, my lord.
Yes.
Yes. So the issue is that their date of births are, my lord, 5/3/1956. By application of FR 56, my lord, they were supposed to retire prior to 31st, my lord. But they retired on 31st. Now the issue is whether they can be deemed to be an employee on 1/4/2016. Well, for that purpose, my lord, I refer to the rules.
Yes.
Page 54 is the rule 4.
Yes. Application of the
Yes.
revised pay.
Application of the revised pay, all employees who were in service on 31st March 2016 or who may have been appointed on or after 1st April 2016 shall draw pay in the revised pay structure applicable to the post grades which they have been holding or which they may have been appointed as the case may be. Now clause B, provided that an employee who was in service on 31st March 2016 may at his her option continue to draw pay in the existing pay band and grade pay pre-revised until the date on which he she wants his her next or subsequent increment in the existing pay band and grade pay or until he she vacates his her post or cease to draw pay in the existing pay band and grade pay. Now, contention of the petitioner is that all employees who were in service on 31st March 2016,
Be deemed to be retired on 1/4/2016.
yes. So he says that since I was on service on 31st March 2016, so I come under this particular clause. But while interpreting that, my lord, clause B has to be taken into consideration. It provides that the meaning of this word, who were in service on 31st March 2016, has to be understood from clause B. An employee who was in service on 31st March and may his or option continue to. The meaning thereby a person, an employee who was on 31st March 2016 in service and continue thereafter because he'll have to submit an option. So in my humble submission, my lord, he doesn't fall it. And second provision is that clause 32, page 55.
Yes.
We fix this pension in terms of this particular provision, my lord.
Yes.
The pension, family pension of the existing pensioners, family pensioners, i.e. pre-1/4/2016 pensioners, family pensioners shall be revised with effect from 1/4/2016 in the following procedure. The revised basic pension, family pension on 1/4/2016 of the petitioners, family pensioners who were drawing pension, family pension on 31/3/2016 shall be fixed by multiplying the existing pension, family pension by a factor of 2.48, and the amount so computed shall be rounded up to the next multiple hundred. The basic pension for all purpose will be so and so. Now clause B is important, Milord. The revised basic pension in no case shall be lower than 50% of the sum of the minimum pay in the pay band and the grade pay thereon corresponding to the pre-revised pay scale pay band from which the pensioner had retired. This is applicable, Milord. This, Lordship will kindly mark this. This is applicable to those pensioners who retired on or before 31/3/2016 and after completing 25-33 years of qualifying service as the case may be. Milord, even assuming there is some confusion in understanding that this clause 1, clause B, Milord, is absolutely clear, Milord. Who are those persons pre-1/4/2016? Are the persons who retired on or before 31/3/2016. So even if we don't go to the judgment, Milord, the rule itself specific that what shall be the interpretation? That the persons who were on engagement or who were on employment on 1/4/2016 will be entitled to the benefit of revised pay. And if someone retires after 1/4/2016, then his pay will be fixed as per the revised pay rule, and thereafter his pension will be calculated on the basis of last pay drawn. Now, there is a communication to, clarification was sought from the Accountant General Office. That letter, your Lordship will find page 63. In the case of Government of Assam employees, what procedure has been followed, Milord? Page 63, it's a clarification given by Senior Accounts Officer, Office of Accountant General.
Yes.
It says, I am to state that fixation of pension and other benefits in respect of employees of the state of the Government of Assam who retired on 31/3/2016 being settled with reference to pay admissible to them as on 31/3/2016 under revision of pay rule 2010. That is the previous pay rule 2010.
Yes.
Now, my lord, Honorable Single Judge, has appreciated this. Para 15, page 101.
Yes.
At this stage, it is apposite to refer to the provisions contained in Rule 4A of the Revised Pay Rule 2017, which pertains to application of revised pay. Rule 4A has laid down that all the employees who were in service on 31/3/2016 or who may have been appointed on or after 1/4/2016 shall draw pay in the revised pay structure pay band with grade pay applicable to the post grades which they have been holding or which they may have been appointed, as the case may be. Rule 4A has thus made reference to two categories of employees. All employees who were in service on 31/3/2016 would be eligible to draw pay in the revised pay structure, pay band with grade pay applicable to the post grades which they had been holding. Similarly, all the employees who have been appointed on or after 1/4/2016 shall draw in the revised pay structure, pay band with grade pay applicable to the post grades to which they may have been appointed. Here, Milord, the Honorable Single Judge, Milord, skip the B portion. There is a category of employee who was on employment on that date and who will continue thereafter, Milord. Now, para 16, in view of the settled position of law that the employees
Yes.
Clause para 16. In view of the aforesaid settled position of law that the employees retire from service in the afternoon of the last day of the month in which he attains the age of superannuation, and from the office order dated so and so by which the petitioner was released from service on attaining age of superannuation of 60 years at 5 p.m. on 31/3/2016, there is no iota of doubt that the petitioner was in service on 31/3/2016, and he also retired from service on 31/3/2016. This court is thus of the view that the petitioner had not acquired the
This
status.
court is thus of the view, yeah.
Yes, Vinod. This court is thus of the view that the petitioner had not acquired the status of pensioner on 31/3/2016. As on that date, he was in service and had also retired from service on reaching the age of superannuation at 5 p.m. He had acquired the status of pensioner only from 1/4/2016. The view gets also fortified from the office order bearing number so and so, which recorded that the petitioner retired on 31/3/2016, and the petitioner was sanctioned pension at the rate of so and so per month only with effect from 1/4/2016. The provisions of Rule 32(1) speaks about the existing pensioners who acquired the status of pensioner pre-1/4/2016, that is previous to or before 1/4/2016, and such a status can be acquired on or before 31/3/2016. Now, para 20.
Yes.
From a conjoint reading of the provisions of the revised pay rule 2017, more particularly Rule 1, Rule 2, Rule 4A, Rule 32, 1AB together, this court is of the unhesitant view that the petitioner who was in service on 31/3/2016 and who retired from service on reaching the age of superannuation also on 31/3/2016 cannot be categorized and bracketed in the category of existing pensioners on 31/3/2016, as he acquired the status of pensioner only on and from 1/4/2016. In such view of the matter, the benefits under the revised pay rule 2017 cannot be worked out by resorting to Rule 32 1AB of revised pay rule 2017, but his entitlements are to be worked out in terms of the provisions of the law laid down in Rule 4A of the revised pay rule 2017. Rule 4A has made the revised pay structure pay band with grade pay applicable to the employees who was in service on 31/3/2016. And the petitioner fall in that category of employee. Therefore, this court is of the view that the respondent authorities shall have to work out the entitlements of the petitioner as pensioner under different head like pension, committed value of pension, CVP, death, retirement, gratuity, leave encashment benefit, etc. And if after such exercise the petitioner is found to be entitled for an enhanced amount, that what has been worked out by the office ordered so and so, and by resorting to Rule 32 1AB of the revised pay rule, the same should be disbursed to the petitioner in an expeditious manner. So, Lord, I relied on the Supreme Court judgment on 2008 14 SCC 699.
Eight,
2008 14 SCC 699. Lordship, दिया ना फिर last time दिया last time yeah.
What is the name of the parties?
Milord, it's Chief General Manager Telecom BSNL and another versus KJ George and others. Not last time, Milord, I gave it.
You are not given the photocopy of that.
Last occasion, my lord, when I argued, my lord, I placed, I'm sorry, my lord, I'm extremely,
But that Kerala and Delhi High Court judgment is there, but not.
oh, I'm sorry, my lord.
Yes.
My apologies. My lord, it's a very small judgment, my lord, 2-page judgment. Para 1, the respondents were working in the telecom department on the post of senior section supervisor and section supervisor and retired on 16/12/1995 and 3/12/1995 respectively. In view of the provisions of FR 56, they were made to retire with effect from the afternoon of 31/12/1995. The report of the 5th Central Pay Commission came into force with effect from 1/1/1996. Clause 3(1) of the 5th Central Pay Commission report states that the revised provisions shall apply to the government servants who retire, die in harness on or after 1/1/1996. The grievance of the respondents raised before the High Court was that they should be allowed to recon their pensionary benefits on the basis of the 5th Central Pay Commission report with effect from 1/1/1996. The division bench of the High Court was of the view that since they were made to retire with effect from 31/12/1995 till the midnight of 31/12/1995, they were in service and therefore entitled to retired benefit from 1/1/1996. We are unable to countenance with the decision of the tribunal and the High Court. As already noticed, they were retired with effect from 16/12/1995 and 3/12/1995 respectively. But because of the provisions of FR 56, they were allowed to retire on the last day of that month. The grace period which was granted to them for the purpose of pay and allowances only. Legally, they were retired on 16/12/1995 and 3/12/1995 respectively, and therefore, by no stretch of imagination can it be held that their pensionary benefits can be reckoned from 1/1/1996. The relationship of the employer-employee terminated in the afternoon of so-and-so respectively. In view of thereof, the order of the tribunal and the High Court are accordingly set aside, and these two appeals are allowed with no order to cost. Now, for the purpose of clarity, my lord, I place the division bench judgment also before your lordship. Kerala High Court.
Jawaharlal, sorry,
Yes,
Union of India and KG George.
yes, my lord. And the reasons assigned by the tribunal and the honorable division bench therein, my lord, almost identical to the reasons assigned by the honorable single judge, my lord. That's why, my lord, I am referring this. Where the respondents who retired, who were in service till 31st December 1995, entitled to the payment of,
Which you are reading?
my lord, this first paragraph, my lord,
Okay.
the facts.
Yes.
Where the respondents who were in service till December 31st, 1995, entitled to the payment of retirement benefits at the rates as prevalent on that day or at the rates as revised with effect from January 1, 1996. The tribunal has upheld the claim of the respondent number 1 and 2. It has taken the view that the two officials had become pensioners on January 1, 1996, and were thus entitled to the benefits of revision. The Union of India, etc., challenged the order. Has the tribunal urged first, the facts will be noticed. The two respondents were working in telecom department on the post of senior section supervisor and section supervisor respectively. They had continued in service till 31st December 1995. They were paid pension with effect from 1st January 1996. Fifth Pay Commission recommended the revision of pension and other retirement benefits. In pursuance to these recommendations, the Government of India issued two separate orders on October 27, 1997. The orders regulated the grant of pension, etc., to the central government employees who were governed by the provisions of the Central Civil Service Pension Rules 1972. The method of fixation of emoluments and pension gratuity were laid down. The two respondents were not given the benefit of the revision of pension, etc., on the ground that they had retired on 31st December 1995. The orders provided the benefit only to those
So
who.
they come to the
Yes.
conclusion.
Yes, my lord.
There are number 9.
Yes. In the case of civil servants, the normal age of retirement is 55 years or 58 years. In the case of central government employees, at the relevant time, the age of superannuation was fixed at 58 years. The rules also postulate that the person would continue in service till the last day of the month in which he attains the age of superannuation. Resultantly, the two respondents has continued in service till December 31st, 1995. Admittedly, their dates of birth were prior to that date. In other words, the two respondents were in service till the midnight intervening December 31st, 1995 and January 1, 1996. As a result of their being in service, they were paid full salary for December 31st, 1995. It is only with effect from January 1, 1996 that they had become entitled to the grants of pension. Should they still be paid pension at a lower rate than that which was made effective by the government with effect from January 1, 1996? The circular dated so and so, a copy of which was produced as Annexure A2 at page 20 of the paper book, provides in paragraph 2.1 that the order shall apply to all pensioners, family pensioners who are drawing pension, family pension as on 1/1/1996, almost identical. Under the Central Civil Service Pension Rule 1972, thus the intention is clear. The orders were retrospective in operation and govern the cases of person who are drawing pension from so and so. Now, Lordship will kindly come to para 16.
Yes.
What is the position in the present case? Respondent number 1 and 2 had admittedly drawn full salary for the month of December 1995. They were paid full wages for the last day of the month, viz. December 31st, 1995. In fact, as well as in law, they were in service of the department till the midnight of December 31st, 1995. It is only when the clock ticks 12 midnight that the relationship of the employer and employee ceases and the status of the pensioner commences. Thus, from January 1, 1996, the two respondents had become pensioners. The date on which the right to claim pension accrues is deemed to be the last working day of the employee. On this basis, the benefit of the circular dated so and so was clearly available to the respondents. Para 19, Milo. We are unable to accept this contention. The two officials had actually continued in service till midnight of December 31st, 1995. It is only from January 1996 that they had ceased to be in service and acquired the status of a pensioner. Resultantly, their claim to pension had to be determined at the rate prevalent on that date. This is precisely what the tribunal has given them. The case is in no way different from that of the Banerjee. In both cases, the pay has been paid till December 31. Finally, Milord, writ petition was dismissed, and this was, Milord, interfered by the Honorable Apex Court. Now, one Delhi High Court judgment, my lord, I placed.
Yes.
2018 SSC Online Delhi 12191. Union of India and others versus GC Yadav. Para 2 are the facts. My lord, para 2, other facts.
Yes.
The Union of India has preferred the present writ appeal to assail the order dated so and so passed by the Central Administrative Tribunal Principal Bench, New Delhi in OA number so and so. By the impugn order, the tribunal allowed the original application preferred by the respondents and held that the respondent applicant is deemed to have retired from service on 1/1/2016. That is the question herein also, Milo. Consequently, the tribunal held that he was entitled to get all his pensionary benefits in accordance with the 7th Pay Commission recommendation. The office memorandum dated so and so issued by the petitioner asserting that the respondents had retired on 31/12/2015 was quashed and set aside, and the petitioner was directed to fix the retirement benefits of the respondents in accordance with the 7th Central Pay Commission, which were implemented by OM dated so and so in respect of the petitioners retiring on or after 1/1/2016. The date of birth of the respondent is 1/1/1956. Considering the age of the retirement superannuation is 60 years, he attained the state age on 31/12/2015. As per the petitioner, the subject retirement is governed by FR 56 in Chapter 9 of FRSR. The said chapter deals with retirement. FR 56 is so far as relevant, rates as follows. I'm sorry.
Yes.
So FR 56A, except as otherwise provided in this rule, every government servant shall retire from service on the afternoon of the last day of the month in which he attains the age of 60 years. In our case, Milord, we are concerned with this particular provision, Milord, the first part. But in the Delhi High Court case, the proviso was applicable because he was appointed on the first day of the month. So that's how
Here
of
they,
the
they were
preceding,
not appointed on the first day of the month.
here not first day, but in between. So that's why we are concerned with the first proviso.
That is that Kerala.
Kerala, yes, Milord. So now I'll just take your lordships to the operative portion. Your lordship will find para 10.
Yes.
Having heard the learned counsel for the petitioners, Mr. So-and-so, peruse the records and relevant rules, and having considered the submissions advanced by the respondent and the decisions relied upon by him, we are of the considered view that the respondent could not be considered to have superannuated retired on 1/1/2016, and he could not be treated as post 2016 pensioner. We are of the view that the impugn order passed by the tribunal cannot be sustained and liable to be set aside. Firstly, we may observe that since the date of birth of the respondent is 1/1/1956, he attained the age of 60 years, i.e. the age of superannuation on 31/12/2015. The respondent appears to be reeling under the impression that he attained the age of 60 years only on 1/1/2016, which is not correct. On 1/1/2016, the respondents entered into the 61st year of his life, having completed his 60 years on 31/12/2015. The issue of retirement in respect of central government servant is covered by FR 56. We have already quoted the relevant extract from the said rule. The first proviso to FR 56A is clearly attracted in the facts of the present case. Since the date of birth of the respondents falls on the first day of the month, i.e. on 1/1/1956, consequently, by virtue of the first proviso to Rule 56A, respondent retired from service on the afternoon of the last day of the preceding month on attaining the age of 60 years. In the case of the respondents, that was the afternoon of 31/12/2015. Even if the expression afternoon is construed broadly, it could only extend to midnight of 31/12/2015, and the same would not cross the said deadline. As at the beginning of 1/1/2016, i.e. from 0 hours of 1/1/2016, the respondent ceases to be a serving employee having superannuated on 31/12/2015. At no point of time on 1/1/2016, the respondents would be said to be in active service. At no point of time in the year 2016, the respondent worked in a post the pay and emoluments which were fixed on the basis of recommendation of the 7th Central Pay Commission. He was not entitled to receive any pay on and from 1/1/2016. Thus, the question of revision of his pay premised on the recommendation of the 7th Central Pay Commission did not arise. The said recommendation became effective from 1/1/2016 in respect of employees who were in service on 1/1/2016, which the respondents was not. Now, if your lordships, one as Banerjee judgment was relied on by the parties, my lord, the division bench held that that is not relevant, and para 17, my lord.
Yes.
As noticed herein above in the present case, by virtue of the first proviso to Rule 56A of FR, the respondent retired on the afternoon of 31/12/2015. He did not see the light of the day as a serving government servant on 1/1/2016. Thus, the decision of say so-and-so Supra was clearly not attracted to the facts of the present case. Now, para 20, my lord.
Yes.
Firstly, in our view, the said decision in so-and-so was rendered in a materially different fact situation. The issue determined by the court was not with regard to the date of retirement superannuation. In fact, on that aspect, the finding returned by the Madras High Court goes contrary to the submission of the respondents that he retired on 1/1/2016 and not on 31/12/2015. Secondly, the relief granted to the petitioner by the Madras High Court since the increment which fell due on 1/7/2013 had been earned by the petitioner by working for the full year, i.e. 1/7/2012 to 36/2013. The same cannot be said about the revision of pay upon implementation of the Central Pay Commission recommendation. Thirdly, the decision of the Madras High Court was only persuasive value, and in fact, in the present case, we don't think that the ratio of the said decision is attractive. Now, para 22. For all the aforesaid reasons, we allow the present writ petition set aside the impugn order passed by the tribunal. We hold that the respondent was not entitled to the pay revision with effect from 1/1/2016 under the 7th Central Pay Commission recommendation, since he superannuated on 31/12/2015, and he was not entitled to the fixation of his pension on the premise that he retired from service on 1/1/2016. So in our instant, in the present case, my lord, the rule came into effect from 1/4/2016, which is discernible from para clause 1 of the rule. So rule came into force on 1/4/2016. Whatever be the, my lord, construction of that particular line in clause 32 or, my lord, clause 4, the fact remains that the respondents, they retired on 31/3/2016, my lord.
Yes.
And both clause B of rule, clause 4, subclause B of clause 4 and subclause B of 32, my lord, clarified if there is at all any, my lord, ambiguity in understanding of the clause A. Both these clauses, my lord, clarified.
Yes.
So, my lord, that was the brief facts of the case, my lord. On the last occasion, my lord, I placed 2 documents before your lordships to show the financial implication that will face. One is, my lord, minutes of the JCC meeting held on 27 to 24. My lord, there is around the total enhanced amount each person will receive is around 40 lakhs per person. And we have 131 numbers.
Regarding this financial implication, if the law says.
True. I'm not harping on that.
Implication we can't take into consideration.
True, my lord. On the last occasion also, that submission I made, my lord, that I am not on the financial implication.
That
I am placing it before your
can't
lords.
be a factor.
Yes, if it
Always.
comes to
That can't
pension,
be a factor always.
correct, my lord. Correct.
If he is entitled for that, then
Will
required to pay. If he is not entitled, not entitled.
So that is what I'm trying to say, that, my lord, going by the provisions of the rule, my lord, he is not entitled. That is my submission. So already we have given, my lord, the excess of
He can't be treated as a pensioner on 1/4/2016.
1/4/2016, and, my lord, by virtue of the directions of this honorable court, my lord, we have already given them the difference, because this honorable court directed to implement the honorable single judge's order. And they have already given an undertaking. There is a direction by this honorable court also that there has to be an undertaking. If final, that will depend upon the final outcome of the. So according to that, they have entered into an indemnity bond that also, perhaps I have placed on the last occasion, and that is the facts.
What is the date of birth of the writ petitioner?
Date of birth of the writ petitioner is, my lord, 5/3/1956.
There are two petitioners or?
Yes, two petitioners, both are same date, my lord,
5/3/19.
5/3/1952.
Date of birth of both?
Yes, yes, both are same. So that is precisely my humble submission before the Lord.
Paid please, your lordship. My lord, my learned friend has not placed the facts in correct perspective. So I would like to place the facts. Now this is, because my lord, every judgment is rendered in the facts of a particular case. Now, how that Kerala High Court judgment and Supreme Court is relevant in our case, we do not know. Because the Kerala High Court and the Supreme Court matter, my lord, that was based on a Government of India Office Memorandum dated 27/10/97. I have got a copy of that. We'll place it. And those are in a totally different context. Therefore, I said, my lord, I must place the facts in perspective. Please come to, my lord, page 41 of the appeal. What is our case? And my lord, they have annexed the writ petition, they have not annexed the annexures. So I'll have to place one or two annexures from the writ petition. Please come to page 41, para 11.
Yes.
That the petitioner begs to state that as per the pre-revised scale and basic pay of the petitioner as on 31/3/16 was 49,320. Now, as per provisions of Rule 4 of the ACB revised pay rule 2017, the petitioner is entitled to 1,40,870 as his last pay as the petitioner was in service on 31/3/16. There is also no dispute that the petitioner is receiving pension with effect from 1/4/2016, but in the pre-revised scale. What the petitioner, this is our case. What the petitioner seeks to contend is that he was in service on 31/3/16. Therefore, in terms of Rule 4A of the ACB revised pay rule 2017, his pension should be calculated as half of the last pay of 1,48,70. That is rupees 70,440, rounded up to so and so, with effect from 1/4/16. However, instead of the same, the respondent erroneously revised the petitioner's pension by applying Rule 32(1)A of the ACB revised pay rule. The petitioner, for ready reference, has given the following chart indicating the basic pay of pre-revised and received amount. Kindly see, my lord, basic pay till 31/3/2016 under the old one was, my lord, kindly see, 49,320 and revised is 1,40,870. So basic pension received is half of 47 odd, my lord, and so it rounds up to 61,170. But if it is calculated as per the revised pay scale as on 31/3/16, then instead of 61,160, I should get 70,440. So there is a difference of about 9,000 rupees, my lord. Then my lord will kindly come to next para. Or please come to, my lord, page 44. Now regarding other, my lord, emoluments. Now, if the basic pay is taken as 1,40,870 at page 44, my lord, then my pension becomes 70,440. Gratuity becomes 15 lakhs. Unutilized leave salary becomes 14 lakhs and odd, whereas I have been given 1 lakh. The second column I have given what I have received. And third column is the amount which is payable to us as per the revised ROP. Then commuted leave value of pension becomes 27,64,000, whereas I have received 9,67,659. So total balance receivable excluding pension is 28,950,407. So in case of each and every pensioner, amount may not be 40 lakhs. It could be less also. Somebody is an accountant. So my lord, this is our case. So what we say is, since I was on service on 31/3/2016, therefore my pay should be revised as per the revision of pay rates, which they have not done. Now, what they have done, my lord, please come to page number 55. Now they have applied this to compute my pension. Now, whether that is correct, that's the only simple fact. We did not read all these judgments, my lord. Para 32. 1. Pension, family pension of existing pensioner, family pensioner in pre-1416, pensioner, family pensioner shall be revised with effect from 1/4/16 in the following procedure. The first question I asked to myself, was I a pre-pensioner on 31/3, my lord, 2016? I was on service. I became a pensioner on 1st of April.
This pensioner, family pension of the annual family pension that is paid, shall be revised.
Pre-1416, my lord. Kindly see the word existing pensioner / family pensioner, that is pre-1416 pensioner. So this 32(1) does not apply to me. While computing the pension, they could not have applied 32(1). That is our simple case, my lord. Now, my lord, what we did, my lord will kindly take the learned single judge's record because they have not annexed the documents. I'll refer to page 26 of the writ petition. Single judge document 9. Oh. Huh? Court gets Okay. Annexure D.
You show us.
One second, my lord. Maybe it is there. Huh? No, my representation. It is there, my lord. Please come to page 57. Asset. Asset, sorry.
Yes.
Yes. Please come to page 57 of the memo of appeal, my lord.
57.
Yes.
It is 7/2/2018.
Yes, 7 to 12. I'll read from the that whole thing, my lord. I have the honor to state that I retired from APGCL as general manager on 31/3/16. After 36 years and 6 months of continuous service, I joined as assistant engineer in the year 1979. From my latest bank statement, it appears that my pension has been revised by multiplying the basic pension by a factor of 2.48 as per subpara 1A of para 32 of the FS memorandum revision of so-and-so dated so-and-so. It is submitted that my pension has been so revised due to misunderstanding of the aforesaid memorandum. Sir, may I draw your attention to para 4 of the above mentioned memorandum, where it states under the heading application of revised pay. all employees who were on service on 31st of March 16, or who may have been appointed on or after 1st of April 16, shall draw pay in revised pay structure applicable to the post grade which they have been holding or to which they have been appointed, as the case may be. My lord, an OM with such a language never fell for consideration either before the Kerala High Court or before the Honorable Supreme Court.
Just a minute. The Honorable Supreme Court clearly said that your relationship with the master
Yes.
was terminated on the date when you attained the age
No,
of 60.
no, my lord, no, my lord.
That's it.
No, I've seen that. I'll come to that. No, I'll come to that.
Let's clarify.
No, yes, it says because on the date of retirement, master servant relationship ceases. Now, my lord, why that observation
On
was
the
made?
date of attaining the age of 60 years.
Yes.
Not on the date of retirement.
No, I know.
Retired later on.
No, that I'll come. My lord, why that observation was made, that also I'll come. Because that was in a totally different fact situation. Now, that's why I'll place that OM which Supreme Court was called upon to interpret, not this OM. Now, please see again, page 57. That, sir, may I draw your attention to para 4 of the above mentioned memorandum, where it states that heading application of revised pay. All employees who were in service on 31st of March 2016 or who may have been appointed on or after 1st of April 16 shall draw pay in the revised pay structure applicable to post grade which they have been holding or to which they have been appointed, as the case may be. Now, if I was on service on 31/12/2016, or if I'm appointed on or after 1/4/2016, then I'm entitled to revised pay scale. Let us not bring in pension here, my lord.
Where is this clause in the notification?
Page 54. 53. 54. My lord, let us not bring pension here. Application of revised pay, page 54. All employees who were in service on 31st of March 16 or who may have been appointed on or after 1/4/16 shall draw pay in the revised pay structure. My lord, there is no dispute that I was on service on 31/3/2016. क्या था? बहुत टाइम लगा.
The judgment is of page, this 2008 14 SCC page.
699. 699. My lord, may I make one submission, my lord? 699, my lord. Which? Yes. Yes. My lord, therefore, our case is very simple. When in the bank statement, I saw that X amount is credited, then I inquired how this amount has been worked out. Then I got to know that they've applied para 32(1)(a). Then you immediately wrote this representation where we say that since I was on service on 31/12/26, 31/3/2016, therefore I am entitled to my revised pay on the last date of my service. The moment it is revised, the pension is a consequence, it will follow. Now, why? Because they did not revise my last pay, therefore, my lord, there was an anomaly in fixation of my pension. Then I appealed to the authority, made several representation. Authority did not act. Then we approached the learned single judge. Yes. Let us see what is wrong in single judge. Again.
Mr. Das, so far you have not paged this clause 4, page 54. Here you are saying something else. You are saying the revised pay scale will be applicable to people who are in, he was definitely on service on 31/3/2000.
Clause 4, page 54.
Yes, page 54.
Yes, my lord.
This is your circular.
Yes,
He was in service on 31/3/2016.
my lord. That is why at the beginning, my lord, I just tried to clarify. If your lordships reads it again, all employees who were in service, because I said B is also has to be read together to understand clause A. All employees who were in service on 31st March 2016. That is, I am in service on 31st March 2016. Or who may have been appointed on or after 1st April 2016. Someone getting appointment after 1st April 2016. I'm sorry.
পইচা নাই তালা মাৰি এচিবি বন্ধ কৰি দিয়ে এনেওতো বৰষুণ দিলে কাৰেণ্ট নাথাকে কালিতো গোটেই ৰাতি কাৰেণ্ট অফিচাৰ কেইটা এচি চলাবৰ কাৰণে বহুত নালাগে নহয় ৰিপ্লাই দিবি Yes. Milord, I was placed, may I now come, please come to page 101, Milord.
101.
Yes, now let us see how the learned single was wrong as my learned friend would like to contend. Here relying on a judgment which is on a different facts. We are totally on a different facts. There is no such clause as 4A in the case which was before the Kerala High Court or before the Honorable Supreme Court.
Yes.
At this stage, it is also apposite to refer to provisions contained in Rule 4A of the revised pay rules of 2017, which pertains to application of revised pay. Rule, see, my lord will kindly note the learned single judge was dealing with right of the petitioner to receive revised pay. Rule 4A has laid down that all employees who were in service on 31/3/16 or who may have been appointed on or after 1/4/16 shall draw pay in the revised pay structure, pay band with grade pay applicable to the post grades which they have been holding or to which they may have been appointed as the case may be. So Rule 4A has thus made reference to two categories of employees. All employees who were in service on 31/3/16 would be eligible to draw pay in the revised pay structure applicable to post grades which they have been holding. Similarly, all employees who have been appointed on or after 1/4/16 shall draw in the revised pay structure pay band with grade pay applicable to post grade to which they have been appointed. In view of the settled position of law that an employee retires from service in the afternoon of the last day of the month in which he attains the age of superannuation, and from office order dated 31/3/16, by which the petitioner was released from service on attaining the age of superannuation of 60 years at 5 p.m. on 31/3/16, there is no iota of doubt that petitioner was in service on 31/3/16 and he also retired from service on 31/3/16. In other words, the petitioner was in service and had also retired from service on 31/3/16. This court is thus of the view that the petitioner has not acquired the status of a pensioner on 31/3/16, as on that date he was in service and had also retired from service on reaching the age of superannuation at 5 p.m. They had acquired the status of pensioner only from and on 1/4/2016. The view gets also fortified from the office order bearing dated 31/3/16, which recorded that the petitioner retired on 31/3/16 and the petitioner was sanctioned pension at the rate of rupees 24,660 per month, only with effect from 1/4/16. Provision of Rule 32(1) speaks about existing pensioners who acquired the status of petitioners pre-1/4/16, that is previous to or before 1/4/16, and as such, a status can be acquired only on or before 31/3/16. Therefore, in my humble submission, my lord, the view of the learned single judge is unexceptionable. There is no scope to substitute this view, my lord, even if there is no possible other view, going by the language of the circular. So therefore, my lord, oh, sorry. Yeah. Master service, they can like into the other place. Huh? Yes, I hear. 130. देखिए देखिए তেল আৰু পানী যোগ কৰিলে যিটো হ'ব এ আৰু বি কৰিলে এইটো তেল আৰু পানী One. Yes. Now, Milord will kindly come to page 51 for once, Milord.
51.
Yes. In pursuance to letter dated 18/12/15, Sri Mukundas, General Manager so is hereby released from APGCL service today, that is 31st of March 16, 5 p.m. on attaining the age of superannuation. So it is their own case that I attained the age of superannuation at 5 p.m. of 31/3/2016. Now my learned friend was trying to read 4B, my lord, in order to understand the purport of 4A. With all respect, my lord, 4B, that proviso is in a different context. Now let us read 4B, my lord. Page 54. Now, I do not know what he was trying to make out, but all that he was trying to make out is to say that to understand the purport of 4A, one must read 4B harmoniously. That is what perhaps my learned friend was trying to say. But I have yet not understood why he was making that submission. Maybe I'm wrong, my lord. B, provided that an employee who was in service on 31/3/16 may at his or her option continue to draw pay in the existing pay band grade pay pre-revised until the date on which he earns his or her next or subsequent increment in the existing pay band and grade pay, or until he vacates his or her post or ceases to draw pay in the existing pay band and grade pay. Well, all that I have understood is, my lord, in case of an employee who has retired on 31/3/16, an option has been given to him or her that so and so can be done. But my lord, 4A is independent. It does not affect the purport by B, my lord. 4A is very clear. Whosoever was on service on 31/3, yeah, Caroline. Hey, 2009 3 SCC hono. Yes, I have 8 to 10. More option access करा नाही. Already more demanding. যদি মই কিবা বিচাৰো তেতিয়া কি হ'ব, that will be governed by that. Yes. Yes. On interpretation of 4A, I'll rely on one judgment of the Supreme Court, my lord. That is 2009, 3 SCC 553, para 39 and 40.
CC
2009, 3 SCC 553, para 39 and 40. Yes. Para 39 at page 567. Your lordship's got it, Miller. Page 567.
Yeah.
If the legislature had intended
Yes.
that the license is required to transfer the land and also to construct the building on it or to make payment for such construction, legislature would have made specific provision laying down such condition explicitly and in clear words, in which event the provision would have been worded in altogether different words and terms. It is a well settled principle in law that court cannot read anything into a statutory provision which is plain and unambiguous. Language employed in a statute is determinative factor of the legislative intent. If the language of the enactment is clear and unambiguous, it would not be proper for the courts to add any words thereto and evolve some legislative intent not found in the statute. 40. In Ganga Prasad Verma, it has been held where language of the act is clear and explicit, the court must give effect to it, whatever may be the consequence, for in that case, the words of the statute speak the intention of the legislature. So, my lord, taking cue from this observation of the Honorable Apex Court, my lord, is it possible to have a second view on 4A, my
The
lord?
general rule of interpretation.
Yes. Therefore, my humble submission is, my lord, Rule 4A is very clear. It says, whosoever was on service on 31/3/16 and whosoever has been appointed on or after 1/4/16 would be entitled to revised pay. So that's the only thing, my lord. So that was not done. Now, my lord, my learned friend relied upon the Kerala High Court judgment, then the Honorable Supreme Court judgment, and the Delhi High Court. My lord, Delhi High Court judgment is out of question, my lord. It does not have any relevance. Now, my lord, to understand the Kerala High Court judgment, if your lordship would kindly take the Kerala High Court order. No, no, no. Now, if your lordship would kindly take that Kerala High Court order for a moment, my lord. In paragraph 2,
Yes.
kindly see, my lord, somewhere in the middle of para 2,
Yeah.
there is a reference to Government of India Order October 27, 97.
Yeah.
So, my lord, the Honorable Kerala High Court as well as Supreme Court was concerned with this OM of October 27, 97. Now, I have given a copy, my lord, please have it. How a decision rendered in these facts can have any relevance here, my lord? Please come to the very first para. Same OM dated 27th of October 97. Here it was effective from 1/1/96. The undersigned is directed to say that in pursuance of government's decision on recommendation of Fifth Central Pay Commission, sanction of the President is hereby accorded to the regulation with effect from 1/1/96. Family pension of all pre-1996 pensioners, family pensioners in the manner indicated in the succeeding paragraphs. So, my lord, the Honorable Kerala High Court and Supreme Court was dealing with cases of pensioners who were pre-1/1/96. Here we are concerned with pensioners of post 31/3/96. So how can a judgment rendered on these facts can have any relevance in deciding the present case where it is covered by 4A, where the language is unambiguous? Now, my lord, regarding that observation that by virtue of FR 56, whatever may be the date you retire on the last date, therefore, you cease to be a government servant after the date of retirement. With great respect, my lord, it has to be confined to the facts of that case. Apart from it, I won't say it is wrong, my lord, but it appears, my lord, it may not be correct. Why I'm saying so, please have FR 56 for a moment. My lord, recently, the Honorable Supreme Court in one of the case from Assam has said, while making a reference of foreigner, it is the duty of the police or the referring authority to find out the address of that Bangladeshi infiltrator regarding his original address in Bangladesh. What will happen to 104 of Evidence Act? And information which is not within the knowledge of the police, how can he prove it? In that case, 104 Evidence Act has to be, my lord, kept somewhere else. So it happens, my lord. Now, please come to FR 56. FR 56A.
Mr. Chaudhary, which bench should deliver that? I've seen the judgment.
I think Honorable Justice Amanullah Khan and some new appointee minor. Because order was passed during a vacation. The Lord will kindly come to 56A. There is a non-obstante clause. Notwithstanding anything contained above, retirement of government employees should take effect from afternoon of the last day of the month in which the employee concerned attains the age of superannuation. So on the face of this, my lord, where is the scope to make that observation that master-servant relationship ceases on the date when he retires? Then, my lord, this loses all its relevance. On the contrary, my lord, on the contrary, a legal fiction is created by FR 56A. And we all know, my lord, as per the rules of interpretation of statute, it is the duty of the Honorable Court to give effect to any legal fiction if it is created. Now, my lord will kindly come to the Supreme Court judgment.
56 or 56A?
56A.
My lord is looking at the central, how to take the state.
State. State, FR 56.
Now, my lord will kindly come to that.
Just
Central আমার বেলেগ নেকি? My lord, the purport is same. There is slight change in the language of the central FRSR
Not
and state FRSR.
So you are referring to state or central?
State, my lord.
State.
Yes.
56A.
56A, there is a non-obstante clause after in the subpara, my lord,
Just a-
before the explanation.
just a-
Notwithstanding anything contained above,
Sir, we have still not been able to get it.
can I hand over this book, my lord?
Page.
Page, my lord, in this book 113. This book, my lord.
Different book.
Oh.
56A तो कुछ नहीं है। Compulsory. 56A deals with compulsory retirement.
B. B is compulsory retirement. A is regarding, my lord, age of retirement. Initially it was 55, then it was made 58, 59, then 60 eventually. 56. No, put it. I was double. এখন কি হয়? হ্যাঁ? I think, my lord, this is an old edition, though it is shown as a revised edition, but the contents are old.
This one.
Looks
Old
like,
one.
man.
This is old one.
Book is a revised one, but contents are perhaps old.
Supply is the photostat copy.
Yes, it's better to we place the gazette nowadays, my lord, because the publishers take it too lightly, my lord. Now, my lord, if your lordship would kindly take that Supreme Court judgment for a moment, that 2008-14 SCC 699.
Yes.
Now, kindly see, my lord, the first para itself.
It's an abbreviation.
At page 700, my lord.
Yes.
The last sentence of para 1,
Yeah.
clause 3.1 of fifth Central Pay Commission report states that revised provision shall apply to government servant who retire die in harness on or after 1/1/96. So this was the issue. My lord, Kerala High Court, by a process of interpretation, sought to give the benefit. It could not have been because they were dealing with this position. That's why, my lord, Honorable Supreme Court rightly interfered in this matter. But
Mr.
this
Chaudhary,
observation regarding
Mr. Chaudhary, how do you explain 32B in the teeth of 4A?
32B.
Yes.
Okay. The revised basic pension in no case shall be lower than 50% of the sum minimum of pay in the pay band and grade pay thereon, corresponding to the pre-revised pay scale, pay band from which the petitioner has retired. This is applicable to those pensioners who retired on or before 31/3/16 and after completing 33 years of qualifying service, as the case may be.
Is this applicable to your client?
No, my lord, in fact,
Why not?
No, my lord. The revised basic pension in no case shall be lower than 50% of the sum of minimum of pay in the pay band and grade pay thereon, corresponding to the pre-revised then from his retired. This is those pensioners who retired on or before so and so, and after completing total service of qualifying service as the case may be. Okay, salary more than so and so. Pension for this lifetime include computation of pension. My lord, B does not, no, B does not determine the
Mr. Chaudhary,
entitlement.
please.
B determines, my lord, the extent of pension.
Do you see any element of repugnancy between 4A and 32B? No, we are
Looks
asking
like.
this, we are asking this for this reason.
Yes.
4A. 4A apparently speaks about application of the revised pay scale in case of those employees who were on service on 31/3/2016, or those who were appointed on 1/4/2000. So that means, in a way, it is a continuity. There can't be anyone in between. So therefore, either someone prior to this or after this, that means it will be applicable to everyone. There is no one who will be left out from the revised pay scale. If you look at it, the plain language of this rule, anybody who was in service till 31/3/2016 or appointed after 1/4/2000.
On or after.
Who else? There can't be any other category
In between.
In between. So it was applicable to everyone. That is the language. Then you come to the fitment clause and pre-revised clause, revision of pension clause. 32 specifically deals with pension. Here, there is a qualification. 32B, the first sentence is qualified by the second sentence, very specifically. There you come in because you are a retiree of 31/3/2016. That position has to be accepted.
Yes.
This aspect of the matter, number one,
Yes.
has not at all been dealt with by the learned single judge.
True.
Secondly, if there is a repugnancy, then unless there is a challenge to one of the provisions, because these are ROP rules, what is the option left for the court? Because you have relied on a judgment which says one has to give meaning to the plain language. So,
Lordship is absolutely correct, my lord. What I am trying to submit is 32A prima facie, my lord, refers to existing pensioner, A. So therefore, the question of application of 32A to us, that is 2.48, does not arise. Now, as the Lordship has very rightly pointed out, let us come to B. Now, my humble understanding, subject to what your Lordship say, B does not determine the entitlement of revised pension. On the contrary, my lord, it lays down the contour of the pension, in what manner and to what extent they will get it. It says in any case, it will not exceed 70,000. And this line, this is applicable to those pensioners. The revised basic pension in no case shall be lower than 50% of the sum of the minimum pay in the pay band and grade pay thereon, corresponding to the pre-revised so-and-so, from which the pensioner had retired. So, my lord, the first sentence does not make any distinction. The first sentence is consistent with 4A. Now we are concerned with sentence B, thereafter. This is applicable to those pensioners who retired on or before so-and-so, after completing so-and-so. Yes. So this will be applicable to those pensioners who retired either on 31/3/16 or before.
Your client retired on 31.
Yes.
So it can't be more than 70,000.
So that is for, my lord, what would be the amount? Now, that my revised pay, my lord, Lordship will kindly not, that's my submission, Lordship will kindly not mix up with my entitlement of the last revised pension, salary and pension. My claim is my claim before the authority, which impelled me to come before the learned single judge, was because I retired on 31/3/2016. Therefore, I say on that day I was entitled to the revised pay. Once the revised pay is fixed, yes, please. My lord, the learned single judge has dealt with it, my lord. Please come to me, Lord, para 12.
Yes,
At page 100.
yeah.
The learned, para 11, the learned counsel for all the respondents have stressed on rule 32(1)(a) and B of the revised pay rule to buttress their point that petitioner is covered by the said rule and there is no applicability of rule 4A in this case. Rule 31B has provided for the procedure of fitment, so and so. For ready reference, rule 32(1)(a)(b) of the release quoted herein below in its entirety. As per sub rule 1 of rule 32, family pension of existing pensioner, family pensioner in pre-1/4/2016 pensioner, family pensioners shall be revised with effect from 1/4/16 in terms of the procedure laid down by sub-clauses A and B. One of the issues that has arisen for consideration is whether procedure laid down in A and or subclause B can be made applicable to the case of the petitioner. It is settled that an employee retires from service in the afternoon of the last day of the month in which he attains the age of superannuation. It is evident from Rule 34 of the revised Pay Rule 2017 that the age of superannuation of an employee of the erstwhile ACB and its successor companies, including AEJCL, is 60 years. By office order bearing dated 31/3/16, petitioner was released from service of the AGCL at 5 p.m. on 31/3/16 on attaining the age of superannuation. Since the meaning of pre is previous to, before the procedure laid down in subclauses A and B of Rule 32 can be made applicable in respect of pension of the existing pensioners of pre-1/4/16, meaning thereby the same can be made applicable in respect of those existing pensioners who had already acquired the status of pensioner previous to or before 1/4/16. By no stretch, pre-1/4/16 can be equated with pre-1/4/16 can be equated with 1/4/16. The revised basic pension in respect of petitioner for which he is aggrieved has been worked by following the procedure laid down in sub-rule A of Rule 32(1). According to the petitioner, his basic pay till 31/3/16 under the pre-revised scale was 49,320, and by multiplying the amount of pension at the rate of so and so as reflected in the office order dated 31/3/16 by factor 2.48, the same has been worked out to 61,157. And by rounding it off to the next multiple of 10, the petitioner is being disbursed a basic pension and at the rate of so and so. My lord, what I have understood is, my lord, in para 13, what perhaps the learned singular judge wants to say, my lord, that this rule 32 would be applicable to pre 1/4/2016 pensioners, not to post.
Understand, but it's immediately noted that 4A is not. And this immediately also.
And my lord,
He is also not a pre-1114. And neither
এটা provision of ODS করিব না।
nor a pensioner. What is?
Now, Lordship will kindly permit me to place two paragraphs, my lord.
Mr. Das, this is all creation of your department. This is needless creation of your department by employing faulty language. If the rules are read in its plain and simple language, you will not be able to explain anything. Rule 4A says revised pay scale will be applicable to those in service on 31/3/2016 and those appointed on or after 1/4/2016. That means on that day the petitioner was in service. Then again you say that in case for pension purpose it will not be applicable. The learned single judge has observed that he is not covered by Rule 4A. He is also not a pre-1/4/2016 pensioner. Then what is he? And the learned single judge, we can feel it because your notifications are totally repugnant. These are repugnant notifications conveying conflicting signals, compelling the courts to give an interpretation.
May I just explain this, my lord? In the entire fact, the most important significant fact is that on which date the petitioner retired.
Mr. Das, we'll go to that. Your revised pay rules was notified with effect from 1/4/2016. Then how have you written in Rule 4A that it will be applicable to employees who are on service on 31/3/2016?
My lord, this, if your lordship, my lord, in the writ petition, only one page of the, my lord, I have given the entire rule. My lord, every page, my lord, I'm just
answer
explaining.
this question.
I'm just
You're
explaining.
giving retrospective effect to your ROP rules.
Sorry, my lord. This rule came into effect from 1/4/2016, my lord. There is no doubt about it.
You have given retrospective effect.
Yes, yes, it is from 1/4/2016. That date.
Oh, it is also applicable in case of employees who are in service till 31.
I'll just explain. I'll just explain, my lord. I'll just explain. My lord, every pay revision rule has two parts. One is for the employees who are there, and another is for the pensioners. Every pay revision of pay rule. Here, my lord.
This much we know, Mr. Das.
Yes,
You can trust us.
no, there is, my lord, I never made this submission thinking that lordship will not know it.
Look,
I'll just
explain the point. Why are you
Yes.
going here
No,
and there?
why I'm making this submission? All the employees who were in service on 31st March 2016 means those employees, that is clause B, provided that an employee who was in service on 31st March 2016, lordship will kindly appreciate, may at his or her option continue to draw pay in the existing pay band and grade pay pre-revised until the date on which he earns his her next or subsequent increment in the existing pay band and grade pay, or until vacates her post ceases to draw pay in the. This means, my lord, an employee, he was in service on 31st/3/2016. He'll be given option whether he wants his increment on the next date or in the eligibility of the, that is on July. say for example, after 6 months. So this includes an employee, or this refers to an employee who was on service on 31/3/2016, who continued with us, who gave his option for remaining in the existing pre-revised pay scale and shifting to the next higher revised pay scale after 6 months, that is from the date of next increment. This is that employee, my lord. So far as petitioner, respondent, one is concerned, he is that employee who falls under 32, that he retired on 31/3/2016. My lord, this, my lord, wards pre-2016, post-2016, with all due respect, my lord, it's absolutely not required, because the main important fact is that when he retired on 31/3/2016. Whether it is pre, whether it is post, whether, my lord, Rule 4A.
My lord, one very important paragraph, my lord, from the impugned judgment.
Yes.
Please come to page 102, para 17, while and a single judge has preferred this view, my lord.
Yeah.
Para 17, 102.
Yes.
By referring to the decision of the Hindustan so-and-so, it has been sought to be asked by Chief Chaudhary, Learned Standing Council, APDCL, that there should be a harmonious construction of the provisions of the revised pay rule and Assam Services Revision Pay Rule 2017. Said decision pertains to different provisions of Income Tax Act, and by referring to different provisions of the said statute, it has been observed therein that provision of one section of a statute cannot be used to defeat those of another unless it is impossible to effect a reconciliation between the two. Now, this is the view of the learned single judge. Thus, a construction that reduces one of the provisions to an useless lumber or dead letter is not a harmonized construction. It has been observed that to harmonize is not to destroy. It has thus been sought to be argued that in case in hand, if the provisions of Assam Service Revision of Pay Rules are read together with Assam State Electricity Board Successor Pay Rule 17, the only interpretation that could emerge is that the benefit of revised can be disbursed to petitioner only in terms of the pre-revised pay structure. There is no dispute that the ratio observed in Hindustan bulk carrier, which made reference to different provisions of the statute for a harmonious construction. In the case in hand, it has been canvassed that there should be harmonious construction of the provisions of the two different sets of rule, that is Assam so-and-so and Electricity Successor Company Revised Rule 2017. Rule 2B of the Assam Revised Pay Rule 17 has specifically made it clear that said rule shall not be applicable to officers and staff of public undertaking of Government of Assam unless specifically extended under express order of the government. In the absence of any express order of the government, the provisions of the Assam Services Revision of Pay Rule cannot be read for the purpose of interpreting the provisions of the Assam State Electricity Board ASCB Successor Companies Pay Revision Rule 2017. It is the harmonious interpretation of different provisions of Assam State Electricity Board and Successor Company Revised Pay Rule 17, which can be made following the ratio laid down in Hindustan bulk carrier. The Revised Pay Rule 2017 have also provided for revision in death-cum retirement gratuity Rule 26, commutation value of pension rule. For example, Rule 26 providing for death-cum retirement gratuity has mentioned that death-cum retirement gratuity provision of Rule 51 of the CCS are applicable to employees of the successor companies, and the amount of gratuity will be 1/4 of the monthly emoluments of an officer employee for each completed 6 monthly period of qualifying service, subject to a maximum of 16.5 times of the monthly emoluments. B, the limit of DCRG has been enhanced from existing rate of rupees 77 lakhs to 15 lakhs. An enhanced limit of DCRG shall be effective from 1/4/16. Similarly, benefit under the heads of cumulative value of pension and leave encashment are made relatable to revised pay structure under revised pay rule of 2017. From a conjoint reading of the provision of the revised pay rule, more particularly Rule 1, 2, 4A, Rule 32, 1, A and B together, this court is of the unhesitating view. The petitioner who was in service.
That you have referred on.
Yes. So, my lord, in this view of the matter, my lord, my humble submission is there is the view taken by the learned single judge is absolutely correct. It does not call for any interference at the hands of this honorable court. On the contrary, my lord, the judgment of the Kerala High Court and which was reversed by the apex court in that KJ George's case were in a different fact situation. Therefore, my humble submission is the appeal is without any merit.
Not only small clarification, so far as the FRSR is concerned, we follow the CCS pension rule. In the ROP rule itself, your lordship, just note it down, my lord. Page 15, clause 24.
Yeah.
Wherein your lordship will find reference with regard to the CCS pension rule. So for the purpose of, we follow the central government.
CCS, service
CCS.
pension rules 54 provide for.
Yes, yes, that we follow. And so far as the judgment relied on by my senior, that is Supreme Court, para 39 and 40, it's
is the
really
position
rather
of law.
covers my case, my lord.
That is position of law.
Yes, the interpretation, my lord, if we
If
go
there
by.
is no ambiguity, court has to read as it is. That's
So
all. That is
my
the settled position.
My submission is that, my lord, there is absolutely no ambiguity in the rules that it could have been interpreted in a
This is
manner.
also the argument of Mr. Chaudhary.
True.
In any case, my lord, if two views are possible, lordships will not substitute
here
the view
there
of
is
the learned single.
no two views.
If two views are possible.
Here there is no
Yes.
two view, that is my
It's a
submission.
writ appeal is an appeal on principle, that's all.
There has to be.
The second applicant pilot is on a fourth day, this is not time.
Retirement date. Retirement date.
No, date of birth.
Yes.
Date of birth, sorry. Okay, same in not on 31st. That's order is there.
DPO.
For pronouncement of judgment, item number 1.
Feel dismissed.
Revert to that. So may I pray that the matter may be fixed.
Business hearing matters now. Why these are
On the last occasion, we are directed to place some materials to show that the director has the power of giving appointment. To that effect, we have to place some documents. That was a query from the honorable, and there was a direction also.
so
First August, your lordship, next Thursday we'll do it.
1st of August.
Yes, sir.
Not as per your convenience.
I'm
at
sorry,
least
I'm
we
sorry.
have to- 29th August.
Deeply open.
Item 24 and 25.
May it please your lordship. My lord, the appellant before your lordship was the successful bidder for a renewal of a road in Makum Rupai bypass in Sugat district. The unsuccessful bidder who was technically disqualified filed a writ petition before this honorable court challenging his rejection of his technical bid. Now, for which the NIT was floated, that your lordship will find at page 71 of the memo of appeal. Page 71, my lord, your lordship will find that it outlines the project detail, including its name, estimated cost, bid value, and completion timeline.
That is not in dispute.
Not in dispute. So the completion time was 12 months.
Come straight to the.
Yes.
point.
Now your lordship will see the
Come straight to the point.
Yes. Now your lordship will
The
see.
conditions, terms and conditions.
Yes. Yes.
And which condition he has not.
Yes. Now your lordship will see page 172, the clause 3 under which it was rejected for deliberate misrepresentation of facts. 172.
172.
172.
This is what the technical evaluation.
Yes,
considers.
yes, yes.
You just first point out which this condition or which clause.
That your lordship will find at page 94.
94.
Yes, sir.
First sure.
Yes, sir. 94, your lordship's got it.
Yes.
2.6.2. 2.6.2 and 2.6.3 at the bottom of page 94.
Yes.
2.6.2, it says, my lord, the authority reserves the right to reject any bid and appropriate the bid security if at any time a material representation is made or uncovered. Then the other part your lordship will omit, then your lordship will look at 2.6.3.
Yes.
In case it is found during the evaluation or any time before signing of the agreement or after its execution and during the period of defect liability subsistence thereof, that one or more of the eligibility and or qualification requirements have not been met by the bidder or the bidder has made material misrepresentation or has given materially incorrect or false information, the bidder shall be disqualified forthwith if not yet appointed as the contractor either by issue of the LOA or LOA will be the letter of acceptance or entering into of the agreement, and if the selected bidder has already been issued the LOA or has entered into the agreement as the case may be, the same shall notwithstanding anything to the contrary contained therein or in this RFP be liable to be terminated by communication in writing by the authority to the selected bidder or the contractor as the case may be, without the authority being liable in any manner whatsoever to the selected bidder or the contractor. In such an event, the authority shall be entitled to forfeit and appropriate the bid security or performance security as the case may be as damages without prejudice to any other right or remedy that may be available with the authority under the bidding documents. Now, your lordship will see.
But this stage has not reached in the matter.
Madam?
This stage has not reached in the matter.
Because in the technical bid, he has misrepresented this
His technical bid was rejected or
for misrepresentation of facts.
only the technical bid was rejected?
Yes.
So this, the only, this, 2.62A is affected.
Yes, yes, madam.
2.63 stage has not reached.
Yes, madam.
That is not reached.
Yes, madam. So your lordship will now see how the technical. The first line will be applicable, my lord, in case it is found during the evaluation or at any time before signing of the agreement. Yes. Technical bid to non-responsive college at 172 to different. The next 172 to go. Right, this one I know. It could be said in case it is found that they during the evaluation or at any time before signing of the agreement or after during the period of effect like this that one or more of the.
Yes.
Yes. Now your lordship will see the round of rejection at page 172. 172. Why the technical bid was rejected, my lord. Clause 3, my lord. Purbanchal Buildtech Private Limited, my lord.
Yes.
Based on the representations, my lord, these representations are part of the record at page 244, which is dated 23/5/2023. My lord, we filed a representation that is the part of this record at page 244. Received regarding the concealment of existing commitments by the bidder named Purbanchal Buildtech Private Limited. Necessary clarification were requested from the relevant heads of the directors, specifically Chief Engineer PWD Border Roads, through TO letter number so-and-so dated 25/5/23. But this letter is also part of the record, which is available at page 246. 245, 11 is 246. In response, the Chief Engineer PWD Border Road Assam through letter number dated 26/5/2023. This is also available at the record, my lord, has confirmed that the bidder did not disclose the mentioned commitments in the bid. This deliberate misrepresentation of facts renders the bidder liable to be disqualified as per clause 2.6.2, that which I have just referred at page 94. Of the request for proposal and their bid security shall be appropriate accordingly as specified in the clause. Consequently, the bidder is considered technically non-responsive.
Yes.
I'll just take your lordship to the representation that we have filed at page 244, annexure 10. Just a cursory glance, madam. Page.
Yes.
244 was the representation filed by us before the appropriate authority, annexure 10.
Page number?
244.
This is your complaint.
Yes, madam. Then in response to my complaint, the PWD wrote to the concerned authorities of PWD border road that your lordship will find at 246.
What is your nature of complaint exactly?
Yes, madam. Page 244, with due respect, I have to inform you that I have pursued in the above mentioned tender with other 5 numbers of contractors. Here your lordship will find Purbanchal the builders is at 4. Then the last paragraph, but it is great unfortunate that 2 numbers of contractor Mohammad Matlebuddin Ahmed now change as Purbanchal Builders Private Limited so and so, sorry, madam, have hidden their ongoing works as mentioned at annexure 1 and close, which is great infringement of tender RFP as per clause 2.6.2. And we have given the details of the works of Mohammad Matlebuddin Ahmed at page 245.
What is this term fair decision? Fair decision.
Well, I could not get your.
Fair decision. What do you mean by fair decision?
Please read the last line of page 1.
Your representation. What is this term fair decision? The interest of fair decision.
It's typing the word honorable as horrible, my lord. It should be fair decision.
If you have written in your representation, there must be some meaning. Fair
Yes, sir.
decision. What is this?
It's a type of fair decision, but you have to take your intent and the entire, you just can't pick up one word and
Not the
say,
fair decision, maybe also-
it should be fair. It ought to have been fair, my lord. There was this interesting episode, my lord, when the manual typewriter was there, then instead of honorable Chief Justice, someone has typed it as horrible Chief Justice, but it's not horrible, my lord. It's always honorable. Then your lordship will see at the page 2 for.
What do you mean to convey?
Printer's devil is
So
very
that-
dangerous. Well, Printer's devil, they say.
Honorable or horrible, what do you mean to say?
Your lordship is always, when you say lordship, we put your lordship in a different pedestal. Man.
Yes.
Well, page 245 is the name of the bidder, my lord. The 3 works that we have mentioned, your lordship will find Mohammad Matlebuddin Ahmed at 245. Yet to start, work in progress, and yet to start. The next page, my lord, at page 245. Name of the bidder, Mohammad Matlebuddin Ahmed. Then in response to our representation, my lord, the page 246, annexure 11, the PWD, Chief Engineer PWD National Highway Works wrote to the Chief Engineer PWD road seeking information or confirmation in regard to the status of the works which we have mentioned. That your communication you'll also will find at page 246.
Yes.
Yes. Then the Chief Engineer, PWD Border Roads, respond to that communication that you also will find in the next page at page 247.
Yes.
Now your lordship will find that all this package mentioned at 247, the date of allotment is 19/9/2022, 2/9/2022, 19/9/2022. And in our case, the NIT was opened on 11/5/2023. So all these works were pending.
For this reason, first of all, you show us the condition where a bidder is required to disclose that he is awarded so and so contract or this he is undergoing these contracts or whatever it may be. Where is that condition?
127, page 127.
127.
Yes, madam.
120,
7. 127, there is a format.
Yes,
Okay.
format.
Yes. Your lordship will find
Yes.
the statement showing the value of all existing commitment, anticipated value of work to be completed in the period of construction of the project for which the bid is invited, and ongoing works as well as the stipulated period of completing remaining for each of the work mentioned even is verified from the certificate issued that has been shown. This is the format where they have to disclose is reflected in page 127. And at the top of page 127, your lordship will find there is a heading written, calculate the value of B.
What is this meaning of B?
Your lordship will find how this B has to be calculated at page 87. It is the bid capacity, my lord. So it starts from page 86, my lord.
Yes.
Now, if your lordship looks at 2.2.2 qualification requirements of bidders, 2.2.2.1 is bid capacity. Bidders who entirely meet the minimum qualification criteria will be qualified only if their available bid capacity is more than the total bid value. That is value as per clause 1.1.1. The available bid capacity will be calculated as per the following based on information made there Annexure 6 of Appendix 1A, that which I have just referred at page 127. And the significance of A and B and C are given. N is number of years, A is maximum value, B is the value updated that B is important, my lord. At page 87, your lordship will find the value B.
Yes.
B, value updated to the price level of the year indicated in table at number 3 below of existing commitments of work for which the bidder has emerged as the winner of the bids or ongoing works to be completed during the period of completion of the works for which bid is invited. For the sake of clarification, it is mentioned that works for which the bidder has emerged as the winner of the bids, but LOA has not been issued as on the day before opening the financial bids shall also be considered while calculating value of B. Then your lordship will look at the note below, just below C. The statement showing the value of all existing commitments work for which the contractor has emerged as the winner of the bids as given by the bidder and the ongoing work as well as the stipulated period of completion remaining for each of the work listed should be countersigned by the client or its engineers in charge not below the rank of so and so and so and so. How this
Yeah, it is a bit quick. It is on the 281. Now what they have to calculation the photos. When I put calculation part of photo. Let us know. It calculate course if like this in the put a second we get it to be by. So we should do. Calculation put in now. Putting the bit to the next question. So what? I mean, one of the numbers. Discussion. Application. What is application factor? Estamos con que cuidarlo. 87. Manco.
Yes. Now, what they have submitted, your lordship will find at page 280. Submitted by Purvanchal in regard to the 5 works is at page 280 and 281. And the
Mr. Kumar,
yes, madam.
just tell us 2-3 things straight away. You can embellish your arguments.
Yes, madam.
These 2 works which there is an allegation of non-disclosure were being carried out by the director in his individual capacity. That's right. And the bidder here is a private limited company, correct? Where the owner is one of the directors.
With 80% of shares.
Right. So according to your client, the work executed by the petitioner number 2 in his individual capacity is the same thing as work executed by the petitioner number 1.
No. What your lordship will then have to look at the page.
No, we'll look
Yes,
at
yes,
the-
yes,
why-
yes, yes.
is
That
this
is
your
not,
case?
yes, ma'am.
The work which were non-disclosed, those are being executed by the petitioner number 1 or petitioner number 2?
Number 2. Petition number 2.
Petitioner number 2 is an individual.
Yes,
That was a proprietorship act.
yes,
Now, the bidder in this case was the petitioner number 1.
yes,
It is a private limited company.
Yes, madam.
Registered company.
yes,
There has to be minimum 2 shareholders of a
yes.
private limited company.
Uh,
Minimum. That's the requirement of law. So that is a different juristic person.
Yes, madam.
Therefore, work executed by petitioner number 1 is different from work executed by petitioner number 2. Let's be very
Yes,
clear on that.
yes.
first.
But
Now, just a minute. Petitioner number 2 complained, your client complained that this man is executing this work. He should have disclosed it in the tender document. And that has been accepted by the committee. And on the ground of non-disclosure, 2.6.2, he was found to be technically invalid.
yes,
Correct?
yes.
Now, please tell us one thing. Is an individual and a private limited company the same person
No,
legally?
no.
Then where is the question of disclosure?
But here, to increase the value of his credentials, he have shown the work which he have individually work completed and not the company.
Acha, he has
Page
included-
347, to increase, because there are two, A and B. A will have to show your credentials, and B is the calculation will go. If we disclose all these three works which are pending, then the credentials value will go down. So in A, to increase his credential value, he shows the work, the company shows the work which was executed by Matlabuddin Ahmed.
As individual capacity.
Yes, that is at page 347.
Is that correct, Mr. Chaudhary?
My lord, the bid capacity required
No,
was,
we'll go to that.
yes,
Is it that he has partly disclosed work done by him individually?
yes, my
and
lord,
partly
because of the law laid down by the Supreme Court in New Horizon, that is permissible. If I join a particular company with my experience goes with that.
Then he should have disclosed the other work. which is-
No, I'll come, no, my lord. End of the day, when a power is given, that power must be exercised for achieving some purpose. It can't be just for the sake of exercising. He will undertake an exercise and find fault.
No, no, Mr. Chaudhary, we'll come to all this. These are legalistic arguments.
Yes,
Let's be straight on the facts.
yes,
He had executed some works individually,
yes,
part of which he included in his tender
yes,
because it favors him,
yes.
part of which he omitted because it didn't favor him.
No, it's not that, my lord. Even if I don't include it or include it, does not make any difference. One second, my lord. See? এই দুটা আমার ভ্যালু কিমান?
কিন্তু সেইটো চাৰিটা কেনেকে মই জানো বাহিৰে মোক মই ইমান ইমান পটকে পটকে ইনকাপ কৰি দিয়ে কোর্টে প্রেরি এটা করে কনফ্লিক্ট বের করতে আমি আমার মতে এইটা আমাকে অ্যাপ্লাই করলে
My lord, the answer is in page number 382. Just
Is that A, B, and C that
at page 87.
page 87?
Another idea is if a person gets so many works, whether he has got the necessary resources and capacity to undertake the work. So that is called bid capacity.
It starts from 86 and 87.
It's a case of selective disclosure.
No, no, no. If a lordship will kindly come to page 246 of the paper book.
Acha, let him finish then.
Your lordship will see the reason for non-disclosure. We'll go by the pleading. Your lordship will find that non-disclosure, why they have not disclosed, is at page 47 of their writ petition, my lord. Page 47, paragraph number 11.
Yes.
That the petitioner has from reliable source have come to learn that while arriving at the aforementioned impugned decision, the tender evaluation committee relied upon some existing pending works in the PWD border roads in the name of one of the directors of the petitioner's company named Mohammad Matlabuddin Ahmed. The said works were pending in the name of Mohammad Matluddin Ahmed in PWD Border Roads, Assam, and not in the name of the petitioner company. Further, unlike the office order dated 21/7/2022 issued by the chief engineer of PWD NH Assam, whereby the existing pending works in PWD NH Assam in the name of Matluddin Ahmed was transferred in the name of the petitioner company. There is no, this is important, my lord, there is no any such order issued by the chief engineer PWD Border Roads transferring the pending works in the name of Mohammad Matluddin Ahmed in PWD Border Roads to the name of the petitioner company. Thus, the said existing pending works in PWD Border Roads, Assam, in the name of Mohammad Matluddin Ahmed was not mentioned in the tender document submitted by the petitioner company. This is important, my lord. There is no any such still company. Now, it is pertinent to mention here that after issuance of the office order dated 21/7/2022, the ongoing works in the PWD National Highway, Assam, which have been transferred from the name of Mohammad Matluddin Ahmed to the name of the petitioner company, were disclosed in the tender document as the said works to transferred in the name of the petitioner company after the office order. Thus, the respondent technical evaluation committee most illegally, what is grounds for in the writ petition is that it is illegal, arbitrary, unjust, and unreasonable. No malafide attributed. Technical bid of the petitioner as non-responsive by taking into consideration some pending works in PWD Border Roads to which the petitioner company is no way connected, and hence the impugned decision is so and so. This is ground for assailing the rejection of his technical bid. Now your lordship will see page 347, where the page 126 format is given and how he have disclosed only the work which increase his credential. Here he says that it was not transferred from one department to another. That's why he did not disclose. But at page 347, he disclosed, my lord, the work your lordship will find. Or PWD Border Roads, my lord. Page 347, my lord.
Yes.
Now your lordship will find entity for which project was constructed. Dear lordship will find CPWD Border Roads and NEC work address Assam Shanmari Guwahati, and date of completion is 31/3/2021. Because our tender notice was last date was
Where do you?
my lord,
347.
entity for which the project was constructed, my lord.
Entity self,
7/7.
7.
Refer instruction 7, then your
Yes,
lordship.
entity for which the work was concerned. Yes.
Yes. CPWD Border Roads and NEC work address Assam Shanmari. Then your lordship will find at date 9, date of completion 31/3/2021. This was in the name of Mohammad Matluddin, my lord. Respondent number 2 here in the memo, in the appeal.
Fine.
Then, so one way, as they are saying, we are not, because the works were not transferred from that particular department to this department, that's why we are not showing. But where the credentials of the petitioners are increased, that work they have shown. Now, there will be always an argument that in spite of all this work being shown or not, the bid capacity of mine will not make any difference, because so far this particular work, I will satisfy the bid capacity. But he has applied for 4 tenders. If the 4 tenders, this value is given, then he will nowhere qualified. That's why he has selected to say that only in this work I will qualify, and he is only concentrating on this work. I'll come to that pilot. Now your lordship will kindly see page 104, the test of responsiveness. So far this tender is concerned, my lord. 3.1.6 is the test of responsiveness, my lord. 3.1.6.1. As a first step towards evaluation of technical bids, the authority shall determine whether each technical bid is responsive to the requirement of this RFP. A technical bid shall be considered responsive only if technical bid is received online as per the format at Annexure 1A. My lord, this is at page 116. Then annexure 1, 4, 5, and 6 bid capacity format, which I've already shown my lord at page 127. And this annexure 1, 4, and 5 is available at page 122.
Yes.
Now your lordship will see page 106, the tender conditions, my lord. 101 at page 106. Three point 1.6.2.
Yes.
3.1.6.2. The authority reserves the right to reject any technical bid which is non-responsive, and no request for alteration, modification, substitution, or withdrawal shall be entertained by the authority in respect of such bid. In the event that a bidder claims credit for eligible project and such claim is determined by the authority as incorrect or erroneous, the authority may reject correct such claim for the purpose of qualification requirements. The authority will get the bid security verified from the issuing authority, and after due verification, the authority will evaluate the technical bids for their compliance to the eligibility and qualification requirement pursuant to clause 2.2.1 and 2.22 of this RFP. Then next 3.1.9. After evaluation of technical bids, the authority will publish a list of technically responsive bidder whose financial bids shall be open. The authority shall notify other bidders that they have not been technically responsive. The authority will not entertain any query or qualification from the applicants who fail to qualify. Then 3.2, opening and evaluation of financial bids. Only when you are technically qualified, your financial bids can be considered, my lord. The authority shall inform the venue and time of online opening of financial bids by the technically responsive bidders through e-procurement portal and email. The authority shall open the online financial bids of the technically responsive bidders only on scheduled date and time in the presence of the authorized representatives of the bidders who may choose to attend. The authority shall publicly announce the bid prices quoted by the technically responsive bidder. Thereafter, the authority shall prepare the record of opening of the financial bids. That will make. Kami kung dia biasa juga kan mahal. Di situ dia nih kan. Situ yang kamu kan. Si kamu kan. Yo. Oh.
Yes.
Oh, aircon is not working, I suppose.
Yeah.
The aircon is not working, I think. Air condition.
No, air condition is working, you are feeling the heat. You are feeling the heat of the job.
My lord, our contention before the learned single judge was that one of the contention was that if you are not technically responsive, then you cannot consider the price bill. But the learned single judge in the impugned judgment at page 425 at paragraph number 34 has taken paragraph number 33 has taken it into consideration. Your lordship will kindly see page 425 paragraph number 33. Last page of the memo of appeal.
That was an additional circumstance.
Yes, ma'am. But even then, my lord, we have taken a ground against that also. Paragraph number 33. At last page of the memo of appeal 425. Next page, Jabisa.
Yes.
So against this paragraph number 33, we have taken a specific ground in this memo appeal at page 31, 7.10. We have, and your lordship will also see the page 423, paragraph number 29.
Yes.
It was strenuously argued on behalf of the contesting respondent that since certain work which were in the name of the petitioner number 2 have been relied by the petitioner number 1 as a part of the credential, the aforesaid 3 work should also have been disclosed. The aforesaid contention, however, cannot countenance in view of the fact that the work which were relied by the petitioner number 1 in support of his credentials were officially transferred to its name, whereas the above 3 works continue to remain in the name of the petitioner. My lord, this was never transferred, but this is not correct, my lord. Your lordship will see the scan of the PWD in regard to this 3 work, my lord, at page 333 in their affidavit, my lord. Page 333, my lord.
Yes.
The second paragraph, my lord. The petitioner company submitted 3 projects in details of eligible project. Project code A, B, and C as the credentials of the company. Out of the 3 eligible projects shown by the petitioner, project code, that is improvement with widening and strengthening, that which was allotted to and completed by Mohammed Matlabuddin Ahmed, and the authority for which the project was constructed is CPWD Border Roads and Any Walk Assam, Chanmari Guwahati 3, which substantiate the fact that the company Purbanchal Buildtech Limited inherited the credentials of Mohammed Matlabuddin Ahmed but the past work even outside the purview of CPWD NH works. Since Assam PWD NH Work Authority had already counted all the credentials, technical, financial, experimental, managerial, and whatsoever so forth from this first day of August 2022 of all the departments for the company project code B, that is improvement with widening and so. Fourth line, my lord, then, which was allotted to and completed by Mohammed Matlabuddin Ahmed, also considered while assessment of the technical capacity of the bidder. The petitioner company themselves have counted a work done by Mohammed Matlabuddin Ahmed under CPWD Border Roads and NEC work as the credentials of the company. Therefore, all credentials of Mohammed Matlabuddin Ahmed, be they technical, financial, experimental, managerial works in any department which are under progress, has been allotted to or completed by Mohammed Matlabuddin Ahmed, shall be counted as the liabilities of the company Purbanchal Buildtech Private Limited as per the supporting affidavits, certificates, undertakings referred in the above mentioned paragraphs above submitted by the bidder itself with the bidding document for the subject work. Deponent further respectfully states that it was also found that the bidder has concealed one of his ongoing commitments, that is improvement of so-and-so road, which was allotted to Purbanchal Buildtech Private Limited, my lord. Petitioner number 1. In this paragraph, he has also concealed one of the work which was granted to Purbanchal Buildtech Private Limited by the CPWD Roads Assam, Guwahati, dated 10/3/2023. As per stipulation of RFP clause 2.2.1, bid capacity value B may be noted of existing commitment, work for which the bidder has emerged as the winner of the bids or ongoing works to be completed during the period of completion of the work for which bid is invited. For the sake of clarification, it is mentioned that work for which the bidder has emerged as the winner of the bids, but LOA has not been issued as on the day before opening the financial bid, shall also be considered while calculating value of bid. Therefore, as soon as a bidder is declared as L1 winner of the bid in any tendering process, the bidder must count the same work as his existing commitments in all subsequent tendering process. Further confirmation regarding the concealment of ongoing commitments as mentioned above had been received from the CPWD Roads, Assam, Chanmari, Guwahati 3, via this letter number dated so-and-so. Accordingly, after receipt of the confirmation regarding liabilities of contractor, it was confirmed that the company concealed their ongoing commitments and misrepresented to the authority, and therefore the company Purbanchal Buildtech Limited stands technically non-responsive as per stipulation of para 2.6.2 of the RFP.
One minute, Mr. Nath. Can you just tell us this two petitioners, petitioner number 1 and petitioner number 2 in the writ petition, they had submitted two different bids for the same work, or only one of them had submitted the bid? Only one.
In the name of?
In the name of proposal.
For?
In the company.
But individually, no bid was submitted.
But there is an affidavit on record. He said that from a particular date, his all personal credentials and everything individual, he will no longer do any business. And everything has been transferred to the company, and now the company will come. It is on. There is an affidavit to that effect. But that in this particular block, the page 265 is that it.
265.
That is for national highway. Yeah, that.
But 264 is that. That consequence of the growth of the business during the last couple of years, for the purpose of management of my business, have formed a company under the name and style Purvanchal Building Private Limited, PAN number so and so, which has since been incorporated under the Companies Act 2013. As per the certificate of incorporation issued on 2/6/2022, having its registered officer so and so. It is the same address followed the petition with the reference number 2. Next page kindly come to 4 block. Consequent of the formation of the said company, all my credentials, technical, financial, experiential, managerial, and whatsoever others so forth from this first day of August 2022 may be counted for the company Purvanchal Buildtech Private Limited for all purposes of fresh bids and contracts for supply and contracted work for roads, highways, bridges, and all other types of construction works under Assam PWD roads, PWD building, PWD NH work, National Highway Authority of India, NHIDCL, CPWD, Irrigation Department, all.
This affidavit is submitted by him before whom?
With the tender.
With the tender document?
Yes, yes. This is the part of the bid.
Violated.
Yes.
May I continue, madam? Micro.
66.
Now, your lordship may kindly look at page 351. The earlier when the learned single judge did not grant a stay on this contractual work because it's a public road. So at page 351 is the earlier division bench order. Your lordship will kindly look at page 351. The relevant portion is at page 352. Okay, put on. Yes, sir. Now you'll also kindly see at page 352, the paragraph 4. Oh, sorry.
Page 331, the query clarified on the document was effectively at page 331, paragraph 4 of our, we have
331?
331 of the appeal memo. Paragraph 4, the last sentence. We have indicated that particular question is a part of the bill.
Yeah, 331.
Paragraph 4, last sentence. In this regard, the deponent respectfully says that the petitioner either Purvanchal Filtech Limited, while submitting their bid, had also submitted an affidavit dated 10/5/2023 and Excel 6, whereby they have mentioned that we hereby certified as so and the 15/7/2022 FS. Those documents are with the bid. That is the fact.
Yes.
Now your lordship will see paragraph number 4 at page 352. On the page 352, paragraph number 4 of the order of the division bench, madam.
On the request.
352. On the request of Mr. D. Nath, it is further clarified that the tendering authorities will be at liberty to take recourse of clause 2.6 of the tender conditions for seeking explanation, additional information from the parties if so advised. Then this recourse was taken. I will take your lordship to that paragraph. But before that, your lordship will also see, because it is a public project, that's why the division bench has observed at just the paragraph before. Needless to say that the appellant shall be at liberty to raise all objection before the learned single judge regarding the arbitrariness of qualifying criteria applied so that. It is also made clear that in case of failure of the appellant in the challenge to the rejection of his technical bid, all consequences will follow as per law. Now your lordship will see the recourse the department has taken, that your lordship will find at 337 in the affidavit. Paragraph number 8. The recourse in pursuant to the order of the Honorable Division Bench, the department has taken recourse, that is at paragraph 8 at page 337, madam.
Yeah.
That the deponent further respectfully states that the petitioner company has filed a writ appeal, being writ appeal number 296 of 2023 against the order dated 31/7/2023, passed in the instant writ petition, whereby the prayer for interim relief made by the appellants in the writ petition challenging rejection of his technical bid in a tender process initiated by NIT dated 11/4/2023 for the work so and so was denied. Then last line, the Honorable Court, after hearing the writ appeal by an order dated 28/3/8/2023, disposed of the writ appeal number 296/20 inter alia with an observation that is so and so, that the appellant shall be at liberty to raise all objection before the learned single judge. The Honorable Court has also clarified that the tender authorities will be, then this paragraph, in view of the Honorable Court order dated 23/8/2023, the respondent authorities have sought for explanation from both the petitioner company and the respondent number 5, and they have submitted their responses. The authorities have already examined and assessed the explanations submitted by the petitioner and the respondent number 5. Three 2023. And that LOA covering letter, your lordship will find at just the page before 348. It is 10/3/2023. And the NIT in this case was issued, the last date was 11/5/2023. So this work of Pumansal was also not disclosed, my lord. Now, an argument was also raised that we too were also